You go back 40 feet, you know.
We're live.
10, 15 feet. But it looked like we were just standing there, there's children, you know, like the game, tell me what's. What's that position he played? Did Willie was safety. No, he was for essentially. Probably this late, obviously, yeah, it and that's how. Yeah, they catch you. Maybe he comes back and whatever. My daughter actually went down hard at decades of work on football, volleyball match. So like football hard getting the volleyball. So I don't know if we feel like we'll take all the books. Side of the game, you know, like so tailgate volleyball plays. Yes.
All rise. The Court of Appeals of the State of Kansas is now in session. The Honorable Angela Coble is presiding.
Please be seated. Good morning. Welcome to the October 15th, 2024 docket for the Kansas Court of Appeals. We have 3 cases on the docket this morning. My name is Angela Coble. As you just heard, I'm one of the newer judges on the court, having just been sworn in the spring of 2022. Prior to coming to the bench, I worked as a litigator in private practice and also as a research attorney to federal judges. To my right is the Honorable Judge Catherine Gardner. Judge Gardner worked as a research attorney in both the Court of Appeals and for a federal judge, as an assistant attorney general for the state of Kansas, and also as a litigator in private practice before her appointment to the Court of Appeals in 2015. To my left is Judge Carl Folsom. Judge Folsom is a district judge in Douglas County, sitting today by designation of the Chief Judge of the Court of Appeals. Before taking the bench, Judge Folsom worked in the Kansas Appellate Defender's Office in private practice and was an assistant federal public defender before his appointment to the Douglas County Court in 2022. The three of us together make up the panel hearing your cases today. So a bit of housekeeping. Can everybody hear okay? Microphones are working. Technology is working. We're good. Okay. We had a few glitches this morning, so I'm glad we're up and running. So we've all read your briefs and reviewed the record on appeal, and we're familiar with the facts of the cases and the issues presented. So just keep that in mind, counsel, as you present your arguments this morning. As the presiding judge, I'll also act as our timekeeper this morning. So if you see me looking at my phone, it's not that I'm distracted. I'm actually using it to keep time. Each side will be given 15 minutes of argument, and appellate's counsel should let us know at the beginning of your argument if you would like to reserve time for rebuttal. So after you present your arguments, the case is deemed submitted for decision. So we'll then take the case under advisement and endeavor to file a written decision as soon as practicable. So with that, I'll call the first case. Our first case this morning comes to us from Wabaunsee County. This is case number 126854, Julie Sylvester, appellant versus Timothy Klein and Noreen Klein, appellees. So let's go ahead and get appearances now. Who is appearing this morning for the appellant?
May it please the court, appellant Julie Sylvester appears in person with counsel Rebecca Rosedool.
Okay, and for appellee?
Doug Thompson appearing declined.
Thank you.
Thank you.
Does appellant wish to reserve time for rebuttal?
Yes, Your Honor, 5 minutes, please.
5 minutes. Okay, granted. Okay, with that, I think we're ready to proceed.
Okay. Judge, would you like me to approach the microphone?
Sure. Please, you can approach.
May it please the court, counsel. I'd first like to begin by thanking the court for allowing us to come here this morning and present on these issues that arise in this case. I represent Julie Sylvester, who is the appellant in this case. She is a longtime farmer. She's been farming her entire life. Her and her husband have farmed their own acres for many years until he passed away about 3 years ago, and she continues to farm on her own from then until now. I want to start by looking and comparing the memorandum agreement written by the district court to the statute. And I think that the district court finds many of the things, makes findings on many of the things important for the statute. If we look at the first prong of the statute, first element, we know that we have to have open, exclusive, and continuous possession of the property. And the district court makes all of those findings and lists them in the memorandum agreement. The district court found that the property was disked by Ms. Sylvester. It was planted. She procured the seed. She planted the seed. She harvested the seed. She herself hauled the grain to the co-op to sell the grain, or she caused each of those acts to happen. She was involved with every one of those acts. And it was a lot different than the case that this court decided a couple weeks ago, which was the Griffin case. It's different from that case in that case, the adverse possessor did not do those acts. The adverse possessor lived in a different state and thought those acts were happening, but still couldn't even testify that they were happening. She didn't know for sure if that 12 or 15-foot piece of ground was actually being farmed by the farmer or not. In this case, is vastly different than that. And Ms. Sylvester was doing each of those acts herself or overseeing them every year that this was going on.
Are any of those, excuse me, any of those elements in dispute really in this case?
I don't think so, because the district court, I believe, hung its hat on two other elements, and one of those is next, and that one is Miss Sylvester's good faith belief that she owned the property. In Kansas, as I know you know, we have two different ways that an adverse possessor can believe that they have possession of the property, and in this case, Miss Sylvester believed that she owned it. She testified all through trial that she believed she owned it. The district court took issue with that because of the deeds filed around 1993 or 1994. There was a deed that was granted back to Elgene and Nora. It's Nola, but I know that the memorandum says Nora. Elgene and Nola Sylvester around that time frame. And it can be confusing because the district court says that because she did that in 1993 or 1994, she knew she didn't own the property. But if we look at the Armstrong case, Armstrong versus City Service Gas Company, that case stands for not having to understand exactly what that deed says. Because if we could understand that, and if we were held to the burden of knowing what that deed said, we wouldn't have adverse possession, because we would just be reading the deed and be held to the meets and bounds description in that deed.
How much land was subject of the quitclaim deed?
It was approximately 5 acres, I believe.
And how much land is she claiming to have adversely possessed?
This is approximately 2 acres. And I say approximately because no legal description exists for it. I know the district court said that a legal description does exist. There's a legal description for the entire 5 acres, but not the part that is claimed under adverse possession. If you looked at Exhibit 1, there is a house sitting there, as you can see. And then in C, around that house, is the land that's being claimed. And I can't tell you exactly how much it is, but it's approximately 2 acres. What's important about that land is there's a pivot, which is an irrigation system that sits on part of that land. And that pivot now cannot leave that property because Applees have built a fence that goes under that pivot, and it cannot swing anymore, and it cannot leave that area. They did leave a hole that they thought it could fit through, but it doesn't. And so that's one of the important factors of this case is that pivot has been there for years and years and years, and it's watered that land and watered the crops that grow on that land for many years now, and it still sits there today.
Council, the district court talked about the two options. You've discussed I guess the claim of the belief of ownership,
Correct.
but the court below also talked about the knowingly adverse option. Do you agree that that's not really in dispute here, that your client's hanging their hat on the belief of ownership?
I can tell you that my client believed that she owned the property. And I guess in a way that she did, if it was found that she did not believe that she owned it, then I guess, of course, it's knowingly adverse because she used it for 28 years.
But is there that element of hostility though in her possession of that property?
Hostility, as I think about the word, no, there was no fighting. There was no outward arguments. But what a hostile taking could have been is she farmed it, she used it, she received all of the income off of it. And so if it belonged to the deed holder was deprived of money and income off of that land for 28 years.
When you're talking about the income from the land, weren't there some shared crop payments with someone else? That's my first question. Then also, she didn't pay the taxes on that land, am I correct?
Well, yes and no. Let's talk about the shared crop first. There were other acres that were owned by Julie and Elvin and and Elgene and Nola. And if they owned them together, I don't know, but they farmed them together. And those acres were split 50-50. In the transcript, you can see testimony of the gentleman that sprayed and the chemical on the property. And he testified that there were other acres that were jointly owned, but not these acres. These acres were 100% Julie Sylvester. She paid the sprayer, she got all of the money for the grain. That didn't apply to this. So I think that that's even further evidence that this was Julie's ground, because there wasn't that share crop applying to this, while it did apply to other properties that were owned and farmed in this by these parties. Now, the taxes. There was absolutely no information presented at trial about the taxes. It says that in the memorandum decision from the judge that he would have liked to see that, but nobody presented that. Now, then, sometime after trial, defendants file this sheet purported to be the taxes, and I filed a motion to strike about that because it was not evidence at the trial. And I know that it is confusing because that does appear in the court's file today because it was filed with the court from defendants, although it was not admitted at trial at all. I think that the first time I ever saw that document is when they filed it with the court after the trial. We went to hearing on that motion to strike, and the judge said that we're not going to get into anything that was not presented at the trial. And the transcript of that motions hearing is in the record. While we're on that subject,
I'm sorry, did the judge grant your motion to strike?
the judge did not make any further findings. He would not. All he said was he would go back and look at the record, and he would know, because it was a bench trial, what was in the record and what was not. And that's all he would leave it at. But if we look at his opinion, it says straight in that opinion that nothing on the taxes was provided at court. And so I think that that would be evidence that it was not. While we're on that topic, I think it's confusing for the court because there are no exhibits of appellees in the file. Their exhibits that they used at court were not attached to the brief. They're not filed with the court. They're nowhere to be found in the file. So when their brief refers back to A and B, that's not A and B in the volumes in the transcript that the court received. And you know that by when you read the transcript, A and B, they're referring to it being a tax form. But if you look at A and B that they have filed with the district court that is in the transcript, those are deeds. So I think that that's confusing to the court that the defendant's exhibits aren't even in front of the court in any manner still as we sit here today. So I just wanted to be cautious that as you look through that and you see a reference back, that it's not referencing exactly how those are numbered in the record.
You just have about one more minute, counsel.
Okay.
And I know we peppered you, so.
And I have another question that I
Yes.
think is important because you're talking about good faith belief that she owned the land.
Yes.
Do you agree that good faith belief, as far as the law is concerned, is not just a subjective belief, but it's based on what is also objectively reasonable?
I do believe that. And I think the Armstrong case talks about that. And it says that knowing that a deed was filed, you're not held to know that exact legal description or it wouldn't be under adverse possession. And it says in there that knowing about that deed does not destroy your good belief, good faith belief.
But they were talking about legal description of land, I believe. And here you've got, she quit claimed 5 acres, which includes this 2 acres that we're talking about today. And just simple math, how do you argue that that was objectively reasonable?
Because I think if you look at the language in the deed itself that was quitclaimed and look at her testimony, she didn't know that it was those pieces of farm ground that she farmed. And then after that deed was filed, the parties built a fence. And the fence was built in 1994, and it outlined the boundary, which the crop ground was on Miss Sylvester's side, and the house and yard was on LG and Nola's side. And they built that fence. And so I don't understand how they would put a fence that was not on the boundary of the property in 1994. And that fence lasts until 2022 when it was taken down by the defendants.
Counsel, wasn't there also testimony that that fence may have been there as early as the 70s?
Yes, and there was a fence there that early, but it was replaced with the new fence. And so I didn't think it was fair to call it there since the 70s.
And ultimately, isn't this just a factual question that the district court resolved against your client?
I don't think the district court resolved the fence against my client at all.
I mean, the good faith belief, isn't that a factual question in light of the deed, in light of all the testimony?
I don't think so, because I don't think the court used the Armstrong case. And I think the Armstrong case is what points us to the good faith belief not being overcome by that deed. I'd like to point out the 2 other cases, if I have any time left, that the court did rely on, one from Virginia and one from Oregon, talking about the heightened level that needs to be applied when this is family members. First of all, there's no cases in Kansas that allude to that heightened level at all. And if we look at the Oregon case, Phil versus Horst, the court actually found in favor of the adverse possessor in that case at a heightened level. And I would think that the level that Miss Sylvester has on this property is actually probably less than the level that Mrs. Fell in that case had in her case. Additionally, in Oregon, it appears that they don't have the good faith belief part of their statute, or at least not in 1970 when that case was developed, because they don't have anything about having that second option like we do in Kansas. And I think that that's an important distinction between those two cases.
But since we do have that option for good faith belief, why does it make sense to adopt the law from another jurisdiction
I
here?
don't think it does. And that's why I'm arguing against the district court using the Oregon and the Virginia case and kind of hanging their hat on those two cases to get the ruling that we got. The same thing with the Virginia case. I don't think that they have the same statute back in, I think it was 1923, or at least in the 1920s that we have today. I don't think that they had the second prong of that statute either. I think that's a very important distinction between the two cases. And that's why I don't think that that Virginia case should be able to be used by the district court. Okay, am I out of time?
Yep.
Thank
I
you.
think- Yep, and you'll have a chance for rebuttal then. Okay, thank you.
You ready
Okay,
for me?
I'm ready.
I'm assuming she used up all of her time. She didn't save any. I'm Doug Thompson. I represent the clients. And the 5 acres that we're talking about,
Is it 5 or is it closer to 2 that are really in dispute for adverse possession?
I think it's total of 5 acres. 3, because of the other 2. Okay, 3. All right. 5 acres. Okay. All right. One of the things I want to share with you with this, of course, is, and I have been through this personally one time in my own life because my dad was killed in a construction accident, and there was 4 little ones and mom. And so we became farmers, and so I understand it. And in this situation here, why this is a family operation, but this family has broken down now. But they used to be a family, and that's not where they're at now. So we're talking about the 5 acres of land. And if we take a look at the 5 acres of land, one of the first things that come out about it is the 5 acres that's in here, of course, was from Eldon and Julie Sylvester, husband and wife. And that real estate was, one of the parties that signed off on it was Julie. She signed off on the 5 acres of land. And that was done back in September 28th of 95 to transfer that property over to Elgene and Nola. And then ultimately they transferred it over to Tim and his wife. And so that's where that part stands in. There's nothing confusing about that. One of the things that happened was she mentioned about the pivot and the land for it, but there wasn't a survey that was done before, or at least an accurate one. And so consequently, the 5 acres that we're talking about, the legal description wasn't matched up with where the property was. And so Tim and his wife, what they had to do, of course, was go down, check out and and get a survey done upon the property. And they did so. And the survey upon the property established where the 5 acres is. The 5 acres is still there. They live on that property. They have their home on that property. And that's their only home. And so, I mean, this isn't a complicated case from the standpoint at all. And,
If there was confusion though, as you mentioned, that there, but maybe was some confusion about the legal description, that there having not been an accurate survey, does that not lend itself perhaps to Ms. Sylvester's reasonable belief about the, differing ownership of that land?
well, I don't think the ownership was at issue at that particular time. Now, there was, well, we have the pivot, we have water, et cetera. And Tim and his wife have the property surveyed. And before they could get all of that completed, why the sheriff's department came out at their request over here and stopped the action and said, you can't do this, you can't do that. Well, they got the survey completed. It was already completed, got the deed work done, and they were in the exact correct position. The old pivot that was there, that was just put into the ground, had been out of there since 2021. And so it wasn't even there. And so they had the survey done and the survey was completed. They came out, they verified it. And so the land that they have and what they have put right there is exactly their land. And it is the correct.
Was it surveyed back
Legal
in 93 when the quitclaim deed was executed?
No, actually, I think it was later than that.
I know that there was a recent survey when your clients
Yes.
inherited it,
Yeah.
but when the quitclaim deed was signed back in the early 90s, was there an accurate description at that point?
Yes, but it just hadn't been surveyed. It was accurate description. By that, I mean, they had the accurate results of it. The opposing side was taking the position that where they had their pivot, where that was theirs. Sorry?
Land descriptions never changes.
Yeah. So that's where that part stands. And I think the judge was exactly right when he made the ruling that he did. I mean, it's very difficult to imagine how she can be on the deed, meaning the opposing party is on the deed, NOLA, and then now saying, well, I want to have that's my 5 acres because we had a spigot out there. We had cattle that walked out there. Well, that's not their property. And this is their property. This was a whole family operation. And if you looked into the situation, why everybody in this room that are involved with the families did some farming, did some livestock, whatever it took for a whole family to take care of it. And that's what happened here. So this property here, we're only talking about the 5 acres. They've already taken care of all of the other property. And, but I don't know what else to say then in this case here, the deed was signed.
Counsel, Ms. Sylvester's counsel mentioned that there are exhibits from district court that aren't in this record. What should we do about that? Was that their responsibility to put them in if we're reviewing the district court's opinion, or should that be held against your client?
Pre-trial.
Yeah, they were submitted to the court at pre-trial before and
I think
approved, but they may not have made it here. I'm sorry.
So if they're not in our appellate record, we don't review those. And so who's I guess who should that be held against? Your client whose exhibits they were, or the appellant who's asking us to review the record?
Well, the trust was formed, the trust was in place. And so it had been signed. All of those documents were well known to each of the parties. And the documents were presented to the court. Now, if they didn't get presented and added into the file, then of course they didn't, but it doesn't change what we're talking about right now, because there was the survey that was done on that 5 acres, and the 5 acres is mapped out, and that's where the 5 acres is being used. And I don't know where the opposing counsel and where they're coming from with this, because I mean, she signed the deed. She signed the deed for this family, putting it over here to them.
Counsel, let me ask you, you know, a lot of our adverse possession cases do not deal with the next gen family farmers or the disputes between families, strangely enough. What do you think about the fact the district court relied on non-Kansas law and sort of, did he apply a presumption that shifted the burden here about when you have a family dispute?
Well, I think that the court handled the best way the court could possibly handle it with the interest of all of the parties involved, because you know, some of the family had passed away now, and so this is a long time operation, but it doesn't change the bottom line with it on here. We're down to, out of all of the acreage that were there, we're with 5 acres. We're talking about 5 acres, and the 5 acres, my clients, like I said, already have, they live there. That's their home. That's everything else with the property. And rightfully so that Julie had signed off on it already on the deed. And so those would have been already taken care of before we get to the stage where we are here. Now, other questions pertaining to anything to do with the property? Because my clients are the ones who paid all of the taxes upon the property.
But counsel, that was not entered into evidence during trial though, correct? The tax information?
You know, it's been a while back. I wish I could tell you exactly that it was or it was not. I think all of that information was presented to the court. Now, so yes, I think it was, because that was a part that came up on that 5 acres of property. Who paid the taxes on it? They paid the taxes on it. And I don't know what else I can do other than she signed the quitclaim deed, transferring it over. And if she's transferred that over to my clients, why then I think that speaks for itself. Tim, did you have anything else? Mm-hmm. Yep. And this would be Exhibit M. Uh-huh. Yeah. And this has the history of the property, which is consistent to what I've just described already.
Okay. Anything else, counsel?
I don't think so, unless you have questions. I'll be happy to take up any of the questions. All right.
Okay.
And it's like I said, I have been through this as an individual, as a little kid that went through this arrangement, and family didn't have any problems whatsoever other than the loss of the husband and dad. Okay, thank you.
Okay. Thank you, counsel. Okay. Appellate counsel?
I know I've said it once, but I just want to reiterate that there was no evidence presented about who paid the taxes. And that's very clear in volume 1. I believe that it was page 86 or 87 where the district court said there was none of that evidence presented. And so I know it appears in the file because they filed it afterwards, but it was not an exhibit that was used at trial.
What is Exhibit M that was just alluded to?
Exhibit
If you don't know.
Well, Exhibit M, if it was the correct Exhibit M, was, I believe it was the snapshot out of the deed book that's maintained at the county on who owned the property. So it'd go back to the deed. It goes back to the deed. I don't know exactly what he had in his hand, but that was Exhibit M at court. We are not taking their house. Julie does not have any interest in their house because she knew that was not her property. The fence line fenced in the house. And it's not 5 acres. It's more like 2. It might be shortly over 2. I don't know. But it's 2 or so acres, and it has nothing to do with their home. It doesn't have to do with their yard. There's nothing going on this property right now because after the district court decision came down, Ms. Sylvester's not farming it. So it's vacant land right now. It's sitting there. It's sitting there with my client's pivot straddling a fence that put in. It's not a recreation area for them. They don't have property on it. Now, there was talk about it being a family farm. It's a,
Can we pause just a second, council? I'm sorry.
there.
There we go. Thank you.
Sorry. There was a lot of talk, and there always has been a lot of talk about this being a family farm. Well, this is a family farm for Julie and her husband and her children. It's not a family farm between the Sylvesters and the Kleins. The Kleins are school teachers. They're not farming the ground. There's no evidence in the trial or in the court that they're out there farming and working the ground. They never had any ownership interest in any of this. If it was a family farm, it's Julie and her children, not Julie and the Kleins. I don't know if there was a survey done back in 1993. I don't believe that there's any evidence in the court about that happening. I believe that there was evidence in the court that there were no markers put in if there was a survey. So I guess neither council should be able to answer that question. Council just said that there was the pivot that had just recently been put there. That pivot had been there for years. That pivot had been there watering the crops underneath this real estate that we're talking about for many, many years. It was not just put there to start this case, and it still remains there today. As it pertains to the fact about there not being any of the correct exhibits for appellees in the case, I believe that that was their job to file those exhibits with their brief if they were not filed with the district court, and they were not filed with the district court. And I just want to remind the court that the exhibits that are filed with the district court do not match the exhibit letters that were used by appellees at the trial. And just to make that clear, if you read the transcript and it talks about exhibit A and B being a tax statement, if you look in the exhibits filed at the court, those are actually deeds, and that's all the way through. The exhibit letters don't match up.
Right. Anything else? Any other questions?
Thank
Okay.
you.
Thank you. All right. Thank you, council. This case is now deemed submitted for decision, so we will endeavor to issue a written opinion as soon as possible. And that concludes this case. Thank you.
Thank you.
Thank you.
Thank you. Okay, we'll go ahead and call our second case of the morning. This case is an appeal from the Kansas Workers' Compensation Board, Appeals Board, case number 126978. Tylesha Pryor, appellant versus Target Corporation, appellee. Once you get settled, council, we'll go ahead and get appearances. Who do we have this morning for the appellant?
Your Honor, on behalf of Alicia Pryor, Jeff Cooper, Law Officer.
Okay, and appellees?
Your Honor, Michael Bandry on behalf of the Appalachian Target Corporation.
Okay. Appellant, do you wish to reserve time for rebuttal?
I would like to reserve just a couple minutes.
Okay, that's granted. Okay, we're ready to proceed when you are.
Thank you. Thank you. My name's Jeff Cooper. I represent Tylesha Pryor, who has appealed this case from the Kansas Workers' Compensation Appeals Board. It's our position that Ms. Pryor is entitled to compensation for impairment attributable to her November 28, 2018 work-related injury. At that time, Ms. Pryor was 34 years old on the date of injury. And prior to that injury, she had no problems, no any kind of impairment of any nature prior to this injury. She was injured lifting some heavy boxes and suffered an umbilical hernia. She had surgery, was off work for a short period of time, returned to work. Some boxes fell on her again. She had a second injury March 19 of 2019. And that was ultimately found to be an aggravation of her first injury. But she only had 3 separate surgeries, including placement of mesh and then subsequently removal of mesh. She has lasting impairment, pain, disability, and, as a result, suffers chronic and intractable problems related to the injury. I want to point out that all the doctors who testify stated she has significant restrictions as a result of the injury. 10 to 20 pound lifting, limits on sitting, standing, etc. Those are all on the record, and I won't go through those. But she was not able to return to work at Target due to her restrictions. They could not accommodate her. And as a result of that, the evidence will show that she was able to find a different job, but has a substantial wage loss. She testified, and the evidence shows she has significant pain as a result of this injury in her abdomen, in her sides, in her back, thighs, groin area. And because of those problems, has those restrictions that both doctors who testified acknowledge. She has problems lifting, bending, squatting, all those kinds of physical requirements. And based on the evidence in the record, the administrative law judge found that Ms. Pryor, claimant, had suffered a separate and distinct injury in her abdominal wall. And there's evidence in there from the doctors about 4 holes in her abdomen to go in and remove the mesh. And the doctors testified that she has myofascial pain with strain of the abdominal wall. And as you may know, a straight hernia by itself is not compensable under workers' compensation. But she has, in addition to the hernia that resulted in these 3 surgeries, 3 holes in her abdomen, and unrelenting pain in her abdominal wall. And that's what the only doctor that gave an impairment rating said. She had a 13% impairment to the myofascial abdomen. And that's the only medical expert that testified about impairment. Dr. Carabetta was asked about impairment, but he said he did not consider the impairment. So I don't believe there's any evidence other than Dr. Axe about her impairment. There's no contradictory evidence that says she doesn't have impairment to her abdominal wall. And we believe the evidence supports that.
Did Dr. Axe say that there's, or did they testify that there is new permanent injury that was related to the initial injury?
Yeah.
Or was it related to the botched surgery?
He testified about that. He said, I believe that the chronic abdominal myofascial pain was related primarily to the removal of the mesh, which would have been treatment for the original surgery.
And that there's a permanent injury based on that?
He did say there is permanent impairment to the abdomen that was separate and apart from the hernia itself.
Did Dr. Carabetta disagree with that?
I don't think he did. If you read his testimony, I believe he said he didn't really consider the abdomen the second time he saw this patient. He was asked some questions about back complaints and some other areas not related to the hernia, and his testimony and his report was limited to that. I asked him if he had issued an impairment rating. He said, no, I didn't look at that. That's outside my area of expertise. So the only opinion regarding the impairment is Dr. Axe.
But it seemed to me that the focus maybe in the briefing was that about her neurological pain or potential neuropathic pain. And in reading both Dr. Axe and Carbata's reports, it seems as though both of them said possible nerve pain, but neither of them were definitive about that nerve pain. And is that enough evidence to find?
I agree. Possible is not enough evidence. We require, more probably true than not. So possible, doesn't carry a lot of weight. So I don't disagree with you there. But what Dr. X did say is that there was a separate myofascial problem. And he said, along with that myofascial, she may have some neurologic symptoms, but, no way to prove that at that point in time. But I think they got over the hernia by his opinion and his rating that's uncontroverted of 13% impairment to the abdominal wall itself, not the hernia. So that's our distinction. And we believe that, that's a valid distinction based upon the credible medical evidence relating to this lady. Alternatively, let me back up just a moment. The administrative law judge found she had a 13% whole person impairment and found that she was entitled to a 48% work disability based upon wage loss and loss of task performing ability. And we believe that is the correct result in this case. I would ask the court to reinstate that. Alternatively, if you believe there was no separate injury, then we believe that KSA 44510D, parent B, parent 22 should be found unconstitutional. The Kansas Constitution, as I know the court's aware, guarantees a citizen an adequate remedy. If this is applied as the appeals board applied it, Ms. Pryor has no adequate remedy and violates the Constitution. It's clear that Ms. Pryor has impairment. All the doctors agree with that. She has wage and task loss. She has inability to do activities of daily living, do sit, stand, walk, exercise, play with kids, etc. It's clear she has impairment. And the board's decision denies any compensation for the permanent impairment injury to the claimant.
But isn't that fact-based?
Fact-based on what? I guess I'm asking.
Well, they just didn't find the injury to the body as a whole. And so.
So Ms. Pryor has impairment. It's uncontroverted based on the evidence from the doctors. And based on this statute, if you apply it the way the board did, Ms. Pryor has no remedy. She has impairment. There's no question. She has significant limitations on her ability to do any activities at work and away from work, activities for enjoyment. Very clear this lady has significant impairment. And if you apply the statute the way the board did, she has no remedy for that.
It isn't, again, following up on Judge Garner's comment, isn't that, that was, part of that was a credibility determination by the board, that they believed one doctor over the other. And that's not something that we, as the reviewing court, can undo, correct?
I don't think you can reweigh the medical evidence, but it's got to support the position. I think if you read Dr. Carabetta's report, he's not supporting anything. He's not controverting. In fact, he agrees that this lady does have abdominal problems, as did Dr. Axe. He did not refute. He just said, I can't rate. It's outside of my area of expertise. Dr. Axe did rate, and there's no allegation that Dr. Axe is not credible, and based on competent medical evidence. I think the appeals board kind of read between the lines of what Dr. Carabetta said. He did not say she didn't have impairment. He said he couldn't rate it because outside of his area of expertise, he said.
But did he state that he thought her injuries and her I'll call them impairments, flowed just from her actual hernia?
He said all the problems flowed from the hernia. He didn't really comment whether there was a separate new condition such as Dr. Axe did, but Dr. Axe clearly said she has abdominal problems, and that's where most of her pain is, in her abdomen. An umbilical hernia, as you probably know, is your belly button. She didn't really have problems there. She had problems in the rest of her abdomen caused by, Dr. Axe's opinion at least, caused by the removal of the mesh. They had to go in there and basically pull that out. And that's what's causing the pain in her abdomen. And that's what Dr. Axe rated. But what I'm getting at, though, is if you disregard that and say, oh, it's just hernia, this is very similar to the Pardo case. This lady has no right of recovery, and the Kansas Constitution guarantees you have a right to recovery for an injury. Now, the Work Comp Act took that away and said you have to file workers' compensation. So there's no adequate substitute remedy if you apply the appeals board's decision here to this lady.
In the Pardo case, there was a shoulder injury.
Right.
There was
no impairment, and they said that was not
there was
permissible.
a second shoulder injury, and they said it's unconstitutional to not deny relief for that second injury, but that's not what we have here, right?
Well, you don't necessarily have a second injury, but what I think if you read the Pardo decision, it says that they were to simply let me get my quote here. Elimination of compensation for permanent partial impairment simply cannot be permissible, even when the worker received compensation for medical bills, which this lady did, and temporary total disability. And she was paid temporary benefits when she was off work on a temporary basis. But what she didn't get, and what Mr. Pardo didn't get, is any compensation for the permanent impairment caused by the injury.
What?
And
Oh, go ahead.
I'm sorry, go ahead.
I was just wondering, why is it the legislature singled out hernias for that type of treatment?
I've been doing this a long time, and that's always been the law. But I don't think it has to be. It's the only statute I know of that limits permanent impairment. And a lot of hernias, you get the surgery, it's fixed. You don't have any impairment.
Nothing permanent.
Nothing permanent. But this lady clearly does. It's uncontroverted. She has significant problems caused by this. And, might have been the second boxes that fell on her that aggravated it. I mean, it made her condition worse, but ultimately they said it's all related to the first injury. It might have been the mesh that was put in there that they had to take back out. But she's got significant problems. She is working and does have task loss and wage loss. And we believe the administrative law judge got that part correctly. But if you look at the recent cases, Pardo and some of the others, clearly there has to be some remedy available to this lady. It's unconstitutional to limit her to workers' compensation and then not provide her any benefits. And as I said, it's the only statute that I'm aware of that limits impairment.
Would you be making this argument about constitutionality if she just had injuries or symptoms related to her hernia? Or
Well, I
is
think it's
your
the
argument-
same thing, yeah.
Is your argument based on the fact that she had more than just that? So she in fact did have permanent injuries?
My argument is if you have a permanent injury, you should be entitled to compensation for that. The evidence in this case, I believe, supports that in addition to the hernia, she had some other problems, and that takes it out of the hernia category. And that's what the judge found. The appeals board changed it and said, no, it's all related to the hernia. I think the evidence supports the administrative law judge's decision more so than the appeals board. But if you're going to follow the appeals board, then I believe the clear evidence and based on the cases, the statute's unconstitutional. You can't deny someone the right to a recovery, and that's what this does. Now, not everybody that has a hernia is going to have impairment, but this lady certainly does. And I've had a lot of cases in the past that people have had impairment from a hernia. Not always, but it does happen from time to time.
Counsel, you're,
Yeah, oh, ahead.
so this statute, has essentially been in place since about 1955 in the current form, is what an industrious, legal attorney, shared with me, and I checked, and as far as Westlaw goes back, it's the same language. The Supreme Court looked at the whole statutory scheme in 1993 and found that it was constitutional. So what can this court do?
Just barely.
Well, what can this court do with that if they've looked at the entire act and said, this is constitutional? Can we even review that? Or can we just give them our opinion on it and have to follow it anyway?
Well, I think you have the ability to give an opinion on that. And I think if you wanted to, you could certainly find it unconstitutional under the same principles as Pardo did in other cases. If it denies a right to a recovery, which our Constitution requires, and that's what Pardo and some of those cases talk about, this statute denies an individual a right to recovery for hernia. And like I said earlier, there's no other injury that I'm aware of in the statutes that denies compensation for impairment. I don't see any logical reason why it should be denied here. So that's my argument. I'd be happy to try to answer any questions you might have.
I
thank
think
you.
for now we're good, and then,
Thank you for your time today.
and even though we went over, it was largely our fault, so I'll still give you a couple minutes for rebuttal.
Yeah, I may not need it all.
Okay.
May it please the court. My name is Michael Bandre. I represent Target Corporation as part of this appeal. The claimant has argued that she's entitled to additional compensation. She did receive the statutory compensation she was entitled to in this case. The question is whether she is to receive any additional compensation beyond what is outlined in KSA 44-510D sub B sub 22, which is a mouthful for a numbering of a statute. I think the first issue is whether or not the decision of the board is supported by substantial and competent evidence. I believe it is. The board has decided that Dr. Carabetta was more credible in his testimony. Dr. Carabetta reviewed this twice. The first time he found that the injury flowed from the initial hernia. The second time he looked to see if there's any additional injuries above and beyond the hernia, the back and those types of things. He found there was not, limiting the injuries to the hernia. Dr. Axe testified, as counsel was indicating, and as is in your record. Dr. Axe found that above and beyond the hernia was just the possible other injuries. Possible injuries don't cut it. It's got to be more substantial than that. The board made that credibility finding between those two physicians, and I believe that finding now establishes that the board's order is supported by substantial and competent evidence. I think the myofascial pain is a result directly of the surgery and treatment for the hernia, and is not an additional injury over and beyond what a hernia is. If you were to go beyond that, anytime there was a surgery for a hernia, now you're looking at additional compensation, and that's clearly not what the statute dictates.
So you're arguing that as a matter of logic, and there's no such testimony in the record?
No, I think it's a factual opinion. So I think it's a factual issue, not necessarily just logic only, but I think it's a factual finding by the Board of Appeals as to the credibility of Dr. Carabetta over Dr. Axe.
But did they really conflict? Did those two testimonies by the doctors conflict?
Only in the effect that Dr. Axe said there was possible additional.
Which he admitted is
Injury.
insufficient.
Agreed. Beyond that, I don't think they do conflict. I think both of them then show that the injuries flowed from the initial hernia. And by KSA 44510D sub B sub 22, there's no additional compensation beyond that. There's been lots of hernia cases where additional compensation has been awarded when there's been a factual finding by the board or administrative law judge that physicians have shown there's something beyond just what has been found from a hernia. But that's not the case here. The factual findings, the medical determinations, were found to be that it's just anything's flowing from the hernia.
But if the board found, and we're looking at, is the board's opinions supported by substantial competent evidence, and the board determined that Dr. Carabatta's report was more credible, but even in Dr. Carabatta's report, he admitted he didn't look at or evaluate her abdomen. So how are we to view that as substantial competent evidence of her abdominal injury?
Because he'd reviewed it the first time he saw her, the first court-ordered independent medical opinion he gave after the box incident showed that everything, in his opinion, flowed from the first hernia issue. And so when he reviewed it the second time, it was on a different question. The second court-ordered independent medical examination was on a separate question of, is there any additional impairment beyond that of what you see from a hernia? And so I do believe that his medical opinions show that it's supported by substantial and competent evidence. I think that's essentially what his opinion found. And I think what is at issue here is whether the burden was met to show that there was additional injuries outside of a hernia. And I think based on the factual finding from the board that there just wasn't. And I again think that's a factual credibility issue between the two physicians. And moving away from that argument to the second issue is on the constitutionality of KSA 44510 sub B 722. Again, there's been multiple times, many cases that we've read that are commented on by the underlying administrative law judge, commented on by the board, where there's been showings that there's been additional injuries over and above beyond hernias, where additional compensation has been granted. What's at issue here is that there just wasn't a factual finding that there was any additional evidence of any impairment beyond what you see from the hernia.
So assuming it was just hernia, why does it make any sense? Why did the legislature carve that out and say you're not going to get permanent disability for that?
Well, again, I don't have anything showing why the decision was made in 1955, but it's been reviewed, the statute as a whole, multiple times since then, and it's been found to be constitutional. Every time that this issue has come up on hernias where they allege something beyond just what's in a hernia, that underlying statute has been found to be a credible statute.
Right, but why does it make sense?
Because the majority of hernia cases where you just have hernias, there is no impairment. And the remedy that a claimant or client would have is showing something beyond just a hernia. But in fact, when anything is just limited to the hernia, the statute still controls. And again, it's a factual medical issue, and that burden's just not been met here on the factual issue of whether there's any additional medical beyond it. The Pardo case is a bit different. The Pardo case is, of course, when the 6th edition guides were introduced, and under the reading of the 6th edition guides, there was no additional recovery for a second injury to the same body part. And the 6th edition guides took away something that was given by statute. Here, that's not the guides that took away anything by statute. The statute's been in place since 1955. And I mean, the statutes clear, it's unambiguous, it's been reviewed before. And I just think this is just strictly a case where the factual medical findings show that there's not an additional injury above and beyond just the hernia.
Well, if the surgery flowed from the hernia, why is that the causal connection not sufficient to say this was the hernia injury
I think it is.
and the mesh removal?
I think it is just a hernia injury. I don't think there's anything above and beyond the hernia. Anytime if you had a hernia surgery at all, you would then, which is the common treatment for any types of hernias, and it's expected, it's even talked about, if there's not a hernia surgery in the statute, you get 12 weeks of compensation. So the hernia surgery is expected, and it's baked into the statute that surgery is an expected course of treatment. And again, anything flowing from that by that statute is not going to have any additional impairment compensation unless you can show something beyond it.
Yeah, well, that's what I was gonna say. Does it make a difference that she actually had 3 surgeries, not just a hernia surgery, but
No, I don't believe it does. I think,
patients and additional surgeries?
I'm sorry, I didn't mean to talk over
No,
you,
no,
Judge.
you're fine.
No, but I don't believe it does. I think they're all related to hernias. Whether there's 3 separate intervening incidents or if they're all related to the first surgery. I think the fact that they're related to the hernia and the hernia treatment by the statute, it offers no additional impairment unless the facts show by credible finding by the board as to the physician testimony, something beyond what is just treatment for the hernia. And I think that's what this gets back to, is Dr. Axe in his testimony was not found to have credibly found anything beyond what the normal treatment was for the hernia. I don't have anything else to present. I know the board's looked at my arguments and briefs, and I'd stand on those.
Okay, thank you, Council.
Thanks so much.
Do you have,
I'll be very brief, Your Honor.
come on up.
Just a couple things I want to hit on that Mr. Bandry said. Dr. Carabetta did not look at the abdomen, did not evaluate the abdomen the second time. He'd seen her 2 years before. And there was the issue of whether she was having some pain in her back and other body parts associated. We recommended some additional testing. But he admitted he did not look at the abdomen, but he did admit, and I put in my brief, that there's no doubt this lady has the abdominal pain, same terms as used by Dr. Axe. And she has that going on. Let me get the correct term here.
Something different than the possible myofascial pain.
Yeah, that was, I'm glad you brought that up. He didn't say she had possible myofascial. He said she had that, and that was related to the mesh removal and the other surgeries she had. He said she has 13% impairment caused by that, and that it was separate and distinct from the hernia. Now, the appeals board, the judge relied on that, and that was the basis for his decision, but the appeals board somehow picked Dr. Carabetta. But I think if you read, and our position is, if you read Dr. Carabetta's reports and his testimony, he never said she didn't have impairment anywhere. In fact, he said she probably has impairment, but he didn't assess that. He didn't look at impairment. He admitted and agreed with Dr. Axe that she had the chronic pain in the abdomen, the myofascial pain. So that's all agreed to by both doctors. But I think you got to read Dr. Carabetta's testimony. He said, I didn't look at her abdomen. And he's not an expert in that. Dr. Axe is a pain management specialist, had done that for many, many years, and is in a position to give an opinion on impairment related to the pain coming from the condition that he says she has.
And chronic pain, is that enough? Is that?
Well, I think, we've had many hernia cases where there's been some entrapment of a nerve, an ilioguinal nerve, and that's more a different kind of hernia. But I don't think there's any evidence per se of a specific nerve entrapped here. Dr. Axe said when you do the surgery, yeah, you have minor nerves, et cetera, that are affected. But he did not provide any impairment for a nerve condition. That's just a result of the trauma from the surgery. Anytime you have a surgery, you have some numbness, tingling, that kind of stuff. But he didn't rate that. He rated the chronic myofascial, which is the muscular problems that she has in her abdomen. Not specifically related to the hernia, but as a consequence, obviously, of the 3 surgeries she had. And I think that's the context of Dr. Axe's deposition, that she probably has this, but we don't have any way to really say that for sure. Other than, her complaints. And he documented those, of course. And that's about all I had, unless you have any questions or anything. All right, thank you.
Well, thank you, counsel. Okay, and like I said, with the other cases, we'll now consider your case submitted for decision and we'll endeavor to get a written opinion out as soon as we can. Okay, thank you. Okay, we'll go ahead and now call the final case on this morning's docket. This case is an appeal from the Shawnee County District Court, case number 125867, State of Kansas, Appalachia versus Purnell Adam Mack, the appellant. So let's go ahead and state some appearances for the appellant.
May it please the court, Purnell Mack appears through counsel Jacob Nowak of the Kansas Appellate Defender Office. May I please request 3 minutes of my time to reserve for rebuttal?
That's granted.
May it please the court, the state appears by Deputy District Attorney.
Okay, we're ready to proceed when you are. Thank you.
May it please the court. Our Supreme Court has warned that trial counsel must walk a delicate line when answering inquiries about potential conflicts of interest. But here, without any inquiry whatsoever, trial counsel preemptively refuted Purnell's claims. They labeled Purnell's complaints against her as misogynistic. They asked the district court to order the bailiff to seize and search her client's phone. They interrupted Purnell twice while he tried to explain his position to the district court. They implied that Purnell was being dishonest and that his actual basis for the motion was simply that he was too nervous to proceed to trial. And they explicitly argued there was no conflict of interest between her and Purnell Mack. Trial counsel did not attempt to walk this delicate line because they did not come to court that day with the intent to protect Purnell's interests. Rather, from the very outset of this trial counsel was there to protect her own self-interests to the detriment of her client.
Is that just speculation?
That's based on my interpretation of her arguments against Purnell Mack's motion to have new counsel put in place, where she spent 16 pages of the trial transcript advocating against that motion, advocating that she did an adequate job preparing this case, advocating that she had done more than enough to prepare for this trial, and where she only spent 1 page during Purnell's closing argument advocating in his defense. I think that stark discrepancy tends to show where her loyalties lied. However, we can go further into the delicate line in this instance, because the delicate line, fortunately enough, presents us also with a bright line on what counsel is allowed to do and not do during these inquiries. They're allowed to recount factual statements for the court. However, they cannot advocate against their client's position or give their opinion on a conclusion of law. They cannot say whether or not they believe a conflict of interest exists. Our Supreme Court has held, based on this delicate line, that a statement that I didn't file a motion to withdraw based on a conflict because I didn't see a conflict crosses the line, advocates against the client, and creates an actual conflict of interest.
What case was that?
That case is Prado, State v. Prado.
Hasn't the Supreme Court in more recent cases backed off that a little bit and allowed counsel to say things like, we don't have a conflict of interest here?
I don't think they've ever gone so far as to say that the statement, we don't have a conflict of interest, is acceptable. They've allowed counsel to give some level of self-reflection on the work they've done. I think it is important that that is done pursuant to a direct question from the court. Because if you aren't answering a question for the court from the court, and you're not responding to allegations that haven't been made, as the trial counsel did in this case, you're just preemptively advocating against the motion that hasn't even yet been made. And when you do that, you're likely violating your duty of confidentiality, because Rule 0.16 is fairly broad on what information can be confidential. It says a lawyer shall not reveal information relating to the representation of a client. That's broad. Unless it's necessary to carry out the representation. It wasn't here because she's not presenting a motion to the district court. It is her client's motion. Or unless you're responding to a court order, the court hadn't asked any questions, or responding to allegations from the client. He hadn't made them yet. She started this when she preemptively refuted the claims. You can't do that as trial counsel. I know my colleague on the other side takes issue with, she doesn't believe that counsel should have to agree that there is a conflict of interest to that extent, and only to that extent. I agree as well. My position is trial counsel should remain silent unless directed by the district court. It's not their motion that's before the court. It is their client's motion. They're not representing him on that motion. It's their client's claims to make.
But how do you distinguish this case and what counsel said here from the more recent Supreme Court case, the ZM case, where counsel actually said, I can't see a conflict? I mean, isn't that similar to what we have here?
That would be more similar to Prado than what we've had in some of the cases where there've just been self-reflection given, although the statement here went beyond that. I don't have a conflict with Mr. Mack is an affirmative declaration. That isn't, I didn't see one, Your Honor, so sorry. To that extent, if I didn't file a motion, you're expressly taking the position that is directly contrary to your client's position.
Counsel, have you ever found another case where a defense attorney accused their client of a crime to the district court?
No,
Find that?
I've at least not on appeal. I've never seen a case to that effect, which is what the trial counsel did in this case when she accused Purnell of secretly recording a conversation between her and the prosecutor, which I think the record pans out that there's at least some dispute about whether or not that occurred. Obviously, his position was that he hadn't done that, but I had never seen that before in an appellate decision. And regardless of whether or not it was a crime, which our position is it was certainly confidential. He said that to her in whatever he said in the furtherance of his representation. And he obviously didn't want to have it brought up before the court. He didn't bring it up in the list of his complaints against his trial counsel. And the trial attorney or trial court noticeably became hostile towards Purnell after that statement was made. Started becoming accusatory, asking him what he did, how he did it, trying to get to the bottom of that. It derailed his complaints. It derailed his ability to advocate for himself, not nearly or more so than his trial counsel interrupting him as he attempted to explain to the court, but it certainly derailed that to his ability to make that argument. And the other problem I have with that is not just simply the crime, which is a problem, because I don't think you can both simultaneously accuse your client of a crime and be representing them in a criminal trial. But the other problem is trial counsel knows what the implications of that are. If the state had actually gotten the opportunity to search that cell phone, our United States Supreme Court has long recognized that cell phones are essentially mini computers that contain the entire privacies of a person's life. Bank records, location data, medical history, text messages, all of that can be determined through a quick Celebrite extraction of a cell phone. And every trial attorney, if you've done this for long enough, has had a case where their client's chances at trial have dropped dramatically just because a cell phone got searched. So it is astounding that not only this attorney saw fit to accuse Purnell of a crime in open court, but also invite the state to seize and search his phone for evidence of that crime, but also that could be used against him in the trial he was there for in that moment.
And when the judge was asking him about what's on the phone, I think he said, and correct me on the facts, that he was documenting his notes with counsel. And so essentially kind of his work product about what happened in meetings and defense strategy leading up to trial.
That's how
accurate?
I understood it, Your Honor, is that he was essentially creating a running document of notes against about his trial preparation. I assume based on that statements that there were also notes about things his attorney did that he didn't like, but essentially a list of notes is what I understood him to be saying. I'm not exactly sure how trial counsel got from that to a secret audio recording, but there was obviously some form of miscommunication between her and Purnell.
Does it matter, counsel? I'm sorry.
Oh, go ahead.
Does it matter or ameliorate the effect at all that the judge took them in chambers, this opposing counsel were present, that it was a chambers conference, first of all, and that that nothing came of the discussion? I mean, does that provide any mitigation at all?
I don't know how going into chambers would necessarily ameliorate the effect of the statement. I'm also not willing to concede that nothing came of the discussion. The district court became hostile towards Purnell and denied his motion for new counsel. I can't say that had no effect on there. And I certainly am not going to say that it had no effect on his sentencing. Purnell got sentenced to the fullest extent of the law in this case. He had a good argument for mitigation. This crime was committed almost 2 decades ago, and it was an awful crime, but he had become a productive, good member of society. There is at least a good faith argument to be made for concurrent sentencing in these cases. But that kind of goes out the window when your trial counsel, the person who's sworn to protect your interest, is up there in front of the district court, accusing you of committing crimes in the present day, accusing you of being a misogynist in the present day, accusing you of being a difficult client who won't show up to meetings, accusing you of lying to the court about why you're actually filing this motion for new counsel. It's tough to take that defense attorney at their word then later at sentencing when they're asking for mitigation or concurrent sentencing or anything of those that ilk. And that's another reason why I think it is best for trial counsel to just remain as silent as possible during these arguments, because they're your client's arguments. And unless the court asks you a direct question, you really don't have any obligation to say anything. It's my time run.
You're at 10 minutes, so
I'm at 10 minutes.
you've got a
Thank you.
couple more.
One last thing I did want to discuss is that Ms. Caprice revealed during this back and forth that she has a uniform policy, or at least a near uniform policy, of not subpoenaing witnesses for her client's defense. That came up because Purnell obviously wanted to exercise that constitutional right to issue subpoenas and compel the attendance of witnesses in his defense, and his trial counsel refused to do so. I'm very troubled by the idea that any trial counsel would feel that they can unilaterally waive their client's constitutional rights to that effect. I would be just as troubled if an attorney said, I have a universal policy to not cross-examine witnesses because for whatever reason, I don't think it's useful.
But assuming it was unreasonable, how is it harmful here? Weren't most of those either subpoenaed by the state, or she had an investigator speak to and found that was not someone she wanted to call?
I think the record reflects that the investigator only spoke with 3 of them. And I'm remembering correctly, there were at least 6 witnesses that Purnell wanted his attorney to meet with. It's why Purnell asked for a continuance of the trial, I think about a month before trial happened, which his attorney objected to, because I think she was too proud to ask for a continuance, because she certainly could have used the time to meet with those remaining witnesses.
But we have no evidence to show what they would have said had they been subpoenaed would have helped your client?
No, we don't. We do know that, had they been subpoenaed, they could have been used to present any sort of a defense on her client's behalf, because she didn't present one. There was no defendant's case in chief in this. There was no opening. She did not cross-examine the majority of the witnesses, including the complaining victim in this case, and then presented at the end of the day a one-page closing argument, which could have been longer had some witnesses come there. We don't have any information about what those witnesses would have said, but the fact that she refused to subpoena them outright conflicts with Purnell's interest in exercising his constitutional right to subpoena witnesses.
If I understand the facts right from the continuance request that was from 30 days before trial, Mac's complaint was that he has some witnesses that he wants his attorney to talk to, and she openly advocated against that continuance. Is that right?
Yes.
And then she, if I'm not mistaken, she said, we'll give these witnesses information to law enforcement and they can interview them. Is that my understanding correct?
That is accurate. She essentially relied on the state's detective to do her trial prep for her, which is obviously not a substitute, because when a state's detective is going to be interviewing witnesses, they're not going to interview them with the defendant's best interests in mind. They're going to be interviewing them with the interest of the state in mind. There's really no substitute for meeting with these witnesses personally, or I suppose with an investigator, although I think you should probably meet with them with your investigator as well, so you can ask any follow-up questions that are necessary. But you certainly can't rely on the state's witness to do your job for them. And the other thing she relied upon was attempting to text message them during voir dire to see if they will show up. That proved unfruitful. It was too little, too late. Some people need subpoenas just to get to court to hand to their employers. There was a complete conflict of interest between Purnell and his trial counsel here, both because she advocated against his interests, because she accused him of a crime, because she sought to have his phone searched and seized, and because she refused to subpoena witnesses for her client's defense.
Counsel, you're pretty much out of time for this argument, but I did want to give you just a minute or so to just briefly touch on the other two issues in this case, the jury instruction issue and the prosecutor's error. So if you could just hit those
Sure.
topics quickly.
Briefly on issue 2, which is the prosecutorial error, I don't see how comparing the defendant's testimony, or not testimony in this case, but statement to law enforcement as a work of science fiction is any different than referring to it as a yarn or a fairy tale or any other euphemism for lying. So we'll stand on our position that that is effectively telling the court or telling the jury that the defendant lied when he gave a statement to the police. Regarding issue 3, which is the jury and which is the super sufficiency issue, or at least it was at one point. Obviously, State v. Reynolds has impacted that argument. We've continued to maintain our argument that the Arkansas Supreme Court has essentially misinterpreted Griffin. I think at this point, given that they have now denied the motion for modification in State v. Reynolds, that is more likely than not an answer or question that's going to need to be resolved by the Kansas Supreme Court. But we maintain that there is a difference between factual inadequacies and legally inappropriate alternative means. And our position under US v. Griffin is this is a legally appropriate alternative means. Thank you.
All right, thank you. I'll give you a little additional time as well.
Thanks, Your Honor. I'm not sure if I'll need it, but may it please the court. Again, the state appears by Deputy District Attorney Jody Litfin. We've hit a lot on the first issue today. I guess I would disagree with the defendant's argument that counsel advocated against him, and assert that her statements really went to whether there was a conflict of interest or not. We disagree that she accused him of committing a crime. We disagree that she told the state to investigate and somehow search and seize his phone, and somehow that could have been used in the current trial. I don't know how that would be possible. I think it all went to the conflict of interest claim. And I think that she brought all of these issues to the district court. There was a motion for new counsel. He said that he wanted to hire new counsel on the first day of trial after the jury had been sworn in. And the history of this case, I think, also is important because, as the district court mentioned, the district court believed that this was a delay tactic, given the timing, which this court can take into consideration, and the district court did as well. There was, I think, always a concern that he wasn't going to show up for trial. He didn't want to be there. He was angry. I think there was all of that sort of history to be taken into consideration as well.
Do you think that his anger might have been based on the fact that she advocated against his request for a continuance 30 days before trial, and then told him that she uniformly does not subpoena witnesses?
And honestly, Your Honor, I didn't go back and look at that motion for a continuance to see whether she did argue. I mean, I'll take your word for it, that that's what happened in the record.
At page 8, if you want to look at it, but she did say that as a policy, I don't subpoena witnesses. So she's waiving his right to compulsory process under the US Constitution and the trial and the Kansas Constitution. So what other constitutional rights does a defense attorney get to waive for their client?
They don't get to waive any, I mean, they don't get to waive any rights for their client. You know, they get to decide whether to testify, but I think that's a matter of trial strategy. And I think that as a matter of trial strategy here, and she did say generally, I think she said, and again, I apologize if I'm not saying it right, but I think she said something like, it's my practice not to subpoena witnesses who do not want to voluntarily come to court. And I think that she had spoken to some of the witnesses that the defendant asked her to, and she had maybe gotten some of those witnesses' names over the weekend by the defendant. So I don't know if she had time. We're speculating a lot of things here, by the way, which I don't think this court should do.
So let's talk about what's in the record then. So you said you disagree with that she accused him of a crime, but she told the trial judge that he recorded a conversation that I had with the prosecutor, and he didn't have the right to record that. Kansas is a one-party consent, and he's not a part of the conversation. How is that not a misdemeanor or breach of privacy that she accused him of?
In the context, I think she's saying, my client told me that he recorded a conversation after he left the.
Right.
Go ahead.
No,
I'm sorry. That's okay.
It led me to another question. How can she disclose that confidential communication? Which, if my understood, she does it to the entire prosecutors there. There's a sheriff's deputy there, the judge is there, and she discloses a confidential communication to the court saying where he just confessed to me that he committed this breach of privacy. So how is that, how is any of that okay? And that's in the record.
It is. And I do believe I think they're in chambers, but I did go back and look. I think the prosecutor's still there, and I think you're correct that a deputy's still there. So this is before they're dismissed.
That's a sheriff's deputy. It's not a court employee. It's a It's a sheriff's deputy, or is it?
I think it's a bailiff who's there. I mean, a sheriff's deputy who's there like for trial.
For courtroom security, but they work for the Shawnee County Sheriff.
Correct. Yeah, that's my understanding. I guess I have to look at it. The state's position is we're looking at it in the context of whether there is a conflict of interest. I don't believe this is confidential communications that was about his case that we're talking about here. It's not about his case at all. It's nothing that he disclosed to her confidentially as a part of their case. It's something that I believe that she brought to the court to say, hey, look, there is this, and I don't know how it was misinterpreted from what the defendant was talking about, but apparently he was talking about some sort of mishandling of her that proved that there was a conflict of interest. So her point was, let's look at this video. If there's a video, he says, that proves that there's a conflict of interest between us, let's look at that video. And I think the court should inquire into that.
She asked so on the record, she asked the sheriff's deputy to take control of his personal phone to search it for whatever this recording is, so they can get to the bottom of it. And then the judge then had questions for the defendant at that point.
Yes, and I have the transcript over there, so I'm not sure exactly how she said it, but I think she said, I'm asking the deputy to seize his phone so we can look at the video, and if he wants to make it an issue, let's review it, or something like that.
So that's on the record, that she revealed a communication that he told her, accuses him of secretly recording her conversation with the prosecutor, which was about something else, and then asks a law enforcement official to take control of his phone and to search it for evidence of that. Would you agree with that?
I mean, that's all in the transcript, yes. But I believe it's in the context, though, of looking to see whether there's a conflict of interest. And I guess I separate those two things from this goes to the heart of, he's claiming there's a conflict. He says there's this video on his phone. If he wants to bring forth what's on this video to prove that there's a conflict, let's look at the video. Not, he committed a crime, let's get him for committing this crime. You know, it was in the context of a conflict of interest. And I don't know if I have anything better than
I
that,
have
Your
some
Honor.
questions about the things that happened later in the trial. And can we consider, after the judge denied the motion to, and I apologize if either of you want to jump in at any point. The later in the trial, I think after the jury was selected, there was an altercation where she told the judge, he stole this paper, and I'm paraphrasing because I don't have it in front of me. I'm not going to be manhandled in front of the jury, and basically says that he, grabbed her without her consent. And I think she said, I'm not accusing him of a crime. Maybe she realized what she was saying, but she accused him of touching her in an aggressive manner, taking some kind of work product without her consent. So how that appeared to me that she was accusing him of misdemeanor battery, but that's after the judge denies the motion. What can we do with that information? Because she also revealed a confidential communication there that she had written down, that I contacted that witness and their response was LOL to whatever he wasn't here to investigate. So another communication, another potential crime. Can we consider that in our analysis at this point?
I don't, because it happened afterwards and the district court didn't make any findings, I'm not sure whether this court can consider it in the motion for new counsel and conflict. So I don't want to call it a hearing, but sort of hearing that happened in chambers. I think that kind of has to be limited to what was brought then.
And if I understand the facts of that right, she had written a note to him about what the witness said. He wanted to keep it. And then when she brought this to the attention of the judge, this altercation, she marked that as that communication as an exhibit, as defense exhibit A, and she put it into the record.
I think that's correct, Judge. I'm sorry, I am not, I didn't review that specific thing before today, but I think that all sounds correct.
Does it sound correct that that's the only exhibit that she offered at the trial, was that private communication with Grant?
That I don't remember. I mean, I know that the defendant's interviews were something that were important to the defense, but I believe the state brought those in. I'm not sure of that, Your Honor, but I wouldn't doubt it if that's true.
And I have one more question, then I'll let my colleagues jump in at some point. Could you find any other case anywhere in any jurisdiction where a lawyer accuses their client of a crime? Let's assume that happened, but where they accuse their client of a crime and then where they remained on the case?
I didn't do any searches for anything out of state, but I don't believe that there is anything in Kansas that I found to have a factual scenario like that from my memory. I guess I would just reiterate our position that we think that the statements that counsel provided here were factual statements and were evaluative statements about trial strategy. And that's kind of the heart of the issue. And we do believe that the district court conducted an appropriate inquiry here. I think that was the first argument made by the defendant, is that the duty to inquire was triggered and that this wasn't an appropriate inquiry. The judge here allowed the defendant to present his complaints and to present what he thought was a conflict of interest. It was uninterrupted by the court, and the court asked 2 additional times after the defendant was done, do you have anything else? Again, the record says what it says, but is there anything else you want to add? And he said, no, that's it, Your Honor. So I think that he did do a proper inquiry here and then allowed defense counsel to respond, provide evaluative statements, and then make the ruling. So we believe an appropriate inquiry was done here. And I think we've kind of gotten into the conflicts of interest claims through Your Honor's questions, but we would, again, disagree that, and we would also disagree that a defense counsel has to agree that there is a conflict. That makes it really hard. And I think Prado makes it hard. And I do think that the court has backed off from Prado, but I think walking this delicate line is very difficult for defense counsel to do in providing these factual statements and arguing against. But I don't think it's like the cases where there's been motions to withdraw a plea or different motions where the counsel has actively argued against the defendant in like the plea situation, which I think Prado was, and other situations where they're making an actual motion of some kind and need independent counsel in those situations.
Counsel, did the district court have any duty, any further duty to inquire after the incident with the paper? I know the court, I think the record reflects the court actually saw that occur. What is your position on that? I know there wasn't an active motion to substitute counsel at that point, but is there some sort of additional duty on the district court's behalf? I mean, to inquire further?
I don't know that there's a situation like that where we've got a case that say that it triggers some sort of duty without being, I mean, I suppose it could be a potential conflict of interest, but it wasn't really brought before the court, so I don't know. I don't know that there is an independent duty. And the court was there to see it too, so I'm guessing that the court had additional information and saw what was going on and could kind of, as best they could, evaluate the situation as it happened. And I think it was clear that defense counsel and the defendant didn't agree on many things on trial strategy, but it's not about the relationship between the two, you know, it's about whether she can advocate for him on his behalf. So I don't know that there was an independent duty to stop right there. I guess I could move on to the second issue, and that's the prosecutorial error claim. And the state's position here is that the prosecutor did not commit error and did not directly, indirectly, or through the use of any euphemism call the defendant a liar. I think there's case law that supports our position stating when a defendant presents a theory of defense, the prosecutor can inform the jury as to what to look for in the evidence. Is there evidence supporting this defendant's theory of defense? What can we look to corroborate that? Is it just a blanket statement? Is it just a blanket assertion that this is what his defense is? And I think that's what the prosecutor was doing, focusing on the evidence that was presented to support his defense that he was set up by SM. I believe SM testified that she didn't set him up. He didn't really have any other evidence to support that. He had the 3 witnesses that I think were called by the state, but it was his mother. I think it was Robin Harrison. I'm probably going to get their names wrong, but it was 3 witnesses who talked about this conversation, potentially a 3-way phone call that happened with SM and how SM said she was going to take care of this or handle it or something like that. So that was presented to the jury to hear, but there was nothing really concrete to back up his statement that SM had planted this condom in the trailer. And also I think it's proper for the prosecutor to kind of logically tell the jury, how does this work out? Like, how do you do that exactly? What evidence did he present that there was a condom, there was my DNA on it, and there was this victim's DNA who no one knew. SM didn't know her. No one knew that she was going to come home. So how does that play out, and what evidence do we have to support that? I think it's different than El Nicky. I think El Nicky, if I'm remembering correctly, there was a detective and there was an interview that was played where he was repeatedly calling the defendant a liar over and over and over. And then that was reiterated in the prosecutor's closing, calling the defendant a liar again and again. And that's not what we have here. I think there's a difference in when there's 2 conflicting stories as here. Either you believe the state's witness who consistently reported that she was, you know, kidnapped, raped, put into a chokehold and forced to have oral sex with one of the victim or one of the unknown other assailant. If you believe her consistent testimony, starting in 2003 to that deputy, going to the nurse, reporting it similarly, and then 17 years later reporting it to Detective Carlett, or do you believe his story that he was set up, his DNA was placed in this condom along with the victims, put in the trailer, and he was set up in that way? I think that the case law supports the prosecutor's position that you can look to the evidence and ask the jury to evaluate what supports that theory. And I think that's the difference here. He wasn't calling him a liar. They were just asking the jury to look and see what evidence corroborates his defense. If this court does find that either of the statements are error, we would argue that it's harmless error. It's our burden to show that. One thing that I've always argued that can be considered is that there was no objection here. This was during rebuttal closing. There was no objection. I don't think that in and of itself means anything, but it can be considered. We would also point to the jury instructions. Jury instruction on statements, arguments, remarks of counsel are not evidence. If anything that they say is not supported by the evidence, it must be disregarded. And also the instruction talking about the weight and credit to be given to each witness, and that the jury is presumed to follow those instructions, which can help mitigate any error if this court finds those statements to be error. And then also secondarily, Sherman talks about the strength of the evidence. And again, he's got that DNA that we have to overcome. His DNA is on the condom, the victim's is, and that's substantial evidence against him and placing him in that trailer back in 2003. So we think the strength of the evidence here also can help establish harmless error. I don't think I have much time, but I would just submit on my supplemental brief for the other issue. I think we just look at it from a regular jury instruction analysis. There was no objection here, and we don't believe that he can prove clear error. We think it's legally and factually appropriate the way that the aggravated kidnapping instruction was given. So I would just rest on my supplemental brief for that, Your Honor.
Okay.
Thank you.
Thank you. All right, Mr. Millwalk, 3 minutes.
Thank you. May it please the court, couple of notes. There was a discussion during state's argument about whether or not Purnell had brought these witnesses to his trial counsel's attention at the last minute or over the weekend before his trial. They were actually brought to her attention on the record at the motion for continuance that she objected to back on April 14th. And trial was on May 9th. It could have been pushed back farther had trial counsel not objected, but all 6 of the witnesses Purnell wanted called and subpoenaed on his defense were named in that hearing. It's record 456 through 58 and page 63. You can find that if necessary. Regarding what happened after the formal motion had essentially closed, I believe this court could consider it if it finds it relevant, because once the duty to inquire is triggered on the district court, defendants don't waive that for failing to raise it throughout the proceedings. That's going to be State v. Brown, which is 300 Can 567 2014. It's also in my preservation section. There was also a comment that the district court believed that this was a delay tactic potentially. It's probably because trial counsel implied it was a delay tactic, which is directly adverse to her client's position when she said he was just a jittery racehorse, didn't want to go to trial because he was too nervous. That if the district court made those findings, that is probably where it got the idea. And last, I just want to rebut the notion that these proceedings are difficult for counsel to go through. They're really not. I've done trial work before. I've had to sit through these hearings. And if you follow the general principle that silence is not only acceptable, but best practice, you're not going to run into a lot of trouble. You should not preemptively rebut your client's claims. They're your client's claims to make. You don't need to correct any factual misstatements. Your duty of candor applies to your statements and statements you put on. Your client's pro se motion, you have no duty of candor towards that. Now you're going to have to answer questions from the district court. Just keep them brief and factual. And if the court asks you directly if there's a conflict, say, I'm sorry, Your Honor, I can't take a position on that. And certainly don't disparage your client during these hearings. Don't refer to them as misogynists. Don't accuse them of committing crimes. And don't tell the court that they are simply trying to delay the proceedings and that they're too nervous to proceed to trial. With that, I'm happy to stand for any final questions, but I would otherwise ask this court to reverse and remand for new counsel or for appointment of conflict-free counsel. Thank you.
Thank you. Thank you, counsel, for your arguments today. This case is now deemed submitted for decision and will endeavor to get a written decision out soon. With that, that concludes our morning arguments, and court will stand in recess. Thank you.
All rise.